Welcome everyone. Myself Divyanshi Khandelwal, a second year law student pursuing BBLLB from United World School of Law, Karnavati University. Currently, I'm interning at Sejpal Associates and Advocates in Ahmedabad, Gujarat. Today, I'll be discussing a very progressive judgment of Sheela Barse versus State of Maharashtra, where the five-judge bench of Supreme Court have laid down certain guidelines for the protection of prisoners, especially women prisoners, against custodial violence and abusive treatment done towards them. This judgment was pronounced on 15th February 1983. Further, we will also discuss about an important element of this case, that is the concept of epistolary jurisdiction, which has played a very crucial role in putting forward the issues and concerns of vulnerable sections before the court. Now, when we talk about the concept of epistolary jurisdiction, it is the unique feature of public interest litigation. The Indian Constitution, in its Article 39A, it also empowers the High Courts of India to exercise epistolary jurisdiction, which provides equal justice and free legal aid. It is the innovative strategy adopted by the Indian judiciary for the protection of human rights. Now, what it means? Epistolary jurisdiction is a process by which a letter by a person or a letter on behalf of an aggrieved person, a telegram or an article in the newspaper is treated as a writ petition by the constitutional courts in India. Now, what are the matters that are to be treated as PIL? It can be about a bonded labor, it can be about an harassment towards neglected children, it can also about non-payment of minimum wages, or it can be a letter from jail regarding a speedy trial of a prisoner, etc. It has been rightly used in various cases. One of such celebrated cases was SP Gupta versus Union of India. So, in order to understand the judgment better, let us first understand the injustices that the people are subjected to. Every now and then, we hear about instances where female inmates have voiced complaints about the harsh treatment and mental and physical abuses done to them by the prison administration. So, in order to guarantee protection from such treatment, our constitution provides various articles, which are Article 14, right to equality, Article 15, clause 3, special provisions for women and children, Article 21, right to life and personal liberty, and Article 22, protection against arrest and detention. All these articles of the Constitution of India give equal rights to women, prisoners, and anyone who have been jailed. Now, let us move towards the facts of the cases. Sheela Barse, a journalist, came to know about the mistreatment of women in the Mumbai Central Jail through an interview of hers with them. During that interview, out of 15 women, 5 women told her about the assaults and tortures done to them by police in jail. She became very worried after coming to know this. So she wrote a letter to the Supreme Court of India stating the same, and under Article 32 of our Constitution, Supreme Court recognized her letter as a writ petition. Soon after the filing of such writ petition, A.R. Desai, the director of Nirmala Niketan, has given a task to interview all such women that were held in the Mumbai Central Jail. He was instructed to do that interview in absence of anyone so that it can be verified whether the claims made in the writ petition of Sheela Barse were true or not. He, after the interview, produced a report where he stated that all the allegations that were made by the women prisoners were absolutely true and right. He also put light upon one more important fact, that apart from all the mishaps, there is no effective structure to offer legal aid to the women prisoners. His report also pointed out that 2 foreign prisoners, one that is German national and second that was Thai national, were duped and defrauded by a lawyer. So the writ petition have raised a lot of issues and brought light to the miseries of women and other prisoners held in Mumbai Central Jail. The most prominent issues that were raised before the Supreme Court of India were whether the rights guaranteed to women prisoners under Article 21, that is right to life and personal liberty of the Constitution of India, are infringed or not. Second, is the state liable for providing legal assistance to prisoners? And third, whether an uncontrolled interview of prisoners was permissible. Before moving towards what has been held, let us first go through the relevant provisions applicable in the present case. Section 46, Clause 4 of Code of Criminal Procedure 1973 talks about mode of arrest for women. It was added by Section 6 of the Code of Criminal Procedure Amendment Act 2005. It provides that in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction such arrest is to be made or such offence is committed. Now, Section 54 of Code of Criminal Procedure 1973 provides for examination of an arrested person by a registered medical practitioner at the request of the arrested person. Lastly, Section 41 of CRPC 1973 lays down certain conditions under which a police officer may arrest a person without a warrant. All of these provisions we will later see how are applied in this particular case. The decision of this case was widely applauded as it provided for the protection of women and other prisoners. The major findings of the court in the present case were: life, as it is provided in Article 21, has a very extended meaning and has a very wide scope, which entitles those persons as well who are detained in prisons either as under trials or convicts. Therefore, the women prisoners were granted right to live with dignity, which has been by far infringed by the jail administration. Now, the court has further held that legal assistance should be provided to poor and helpless who are being arrested, as it is a constitutional mandate provided by Article 14, right to equality, Article 21, right to life and personal liberty, and Article 39A, equal justice and free legal aid of the Constitution of India. Now, imagine the helpless condition of a prisoner who is in jail and does not know whom he can turn for help in order to prove his innocence or defend his constitutional or legal rights, or to protect himself against torture and ill treatment at the hands of police and jail administration. Therefore, it is very absolutely essential that legal assistance must be made available to all the prisoners, as it's an important requirement of justice towards them, and where it is not provided, injustice is likely to result. Now, looking at the matter, the court has directed the social workers to make report of the female prisoners regarding any ill treatment that has been done to them in the lockups. The court further held that interviews shall not be uncontrolled and must be cross-checked with the competent authorities. Also, such interviews with the prisoners should be done within the site but out of the hearing of the jail officials. The Supreme Court in this particular case has given certain directives to Inspector General to issue a notice to jail administrator regarding: first, send a list of all the under trial prisoners and the crimes committed by them with a separate list of all the males and female prisoners. Second, a list giving the particulars of persons arrested on suspicion under Section 41, which states conditions under which police may arrest a person without warrant who have been in jail beyond a period of 15 days. Third, a list should be put up by the police officers at prominent places of jail regarding the lawyers appointed to the prison people. And lastly, facilities should be provided to lawyers so that they can assess the detainees properly. Apart from the other directives, the most prominent directives were given for the safety of women prisoners, which are stated as follows. First, there should be separate 4 or 5 lockups for female prisoners, and it should be guarded by female police officers only. Interrogation of the female prisoner should only be done in the presence of female officers only. Third, the person arrested without a warrant should be informed about the ground of arrest and provision of bails. And lastly, female should not be arrested before sunrise or after sunset according to Section 46 Clause 4 of CRPC, which has been previously mentioned. The court has further advised certain authorities to strengthen the legal aid mechanisms that is provided to the prisoners. That is, the Supreme Court issued a notice for establishing legal aid committee at High Court and district levels and advised the district level committee to designate a couple of district court practicing attorneys to periodically visit jails to check on implementation of orders issued by the High Court and Supreme Court. Apart from these guidelines and apart from all the directives, there were certain two other guidelines which are not only applicable to women prisoners in particular but to the prisoners in general. That are, as soon as the person is arrested, his family or friends are to be informed about the arrest and the police should also give intimation to the nearby legal aid committee for legal assistance. And last, the person arrested must be brought before a magistrate who will ask about complaints regarding any torture or mistreatment in police custody that has been done to that prisoner and advise them of their entitlement to a medical examination under Section 54 of the Criminal Procedural Code. So this was all about the case of Sheela Barse versus State of Maharashtra, which has provided for the protection of prisoners in general and safety of women prisoners in the prisons of our country. Thank you for watching this video, and if you liked the video, please like, comment and share.